What I would
Madam
tell you
Secretary,
is that we are following court orders, and that your advocacy for a known terrorist is alarming to me.
Madam Secretary,
it's alarming to me because he's a human smuggler.
Madam
He's a
Secretary,
wife
I'm going to have to
beater
reclaim
and a
it.
terrorist, and he's not a U.S. citizen. He's a citizen of El Salvador, and he's home. If he were to come back
Madam
here,
Secretary,
we would take him immediately.
All right,
back
I'm going to have
El
to, Madam Secretary, you should know a couple facts then, which is, number one, in 2019, the immigration court said that he should not be returned to El Salvador because it would put his life in danger. The Trump administration at the time did not appeal that decision. After that, he got a work permit and was working legally in the United States of America. This is also why the district court and the appellate court and the Supreme Court have ruled as they have. I suggest that rather than make these statements here, that you and the Trump administration make them in court under oath, because despite what you just said, the federal district court, whose judge is hearing this case right now, said, and I'm quoting, that the administration has provided no evidence linking Abrego Garcia to MS-13 or any other terrorist activity. I'm not vouching for the man. I'm vouching for his due process.
Senator Van Hollen.
Thank you, Madam Chairman. Madam Secretary, it's good to see you.
Good to see you too.
And I was glad to see in your recent testimony that you reaffirmed your obligations to uphold the Constitution of the United States. And I understand you had an exchange with Senator Murphy on the Abrego Garcia case. And so I'm just going to put the question directly to you. Are you or DHS doing anything to comply with the 9-0 Supreme Court order to facilitate his return to the United States? Just yes or no.
This administration is following all federal court orders.
This is a
it's
simple
the
question.
president's prerogative on conversations that
Madam
happen
Chair,
with the president of El Salvador.
I ask a simple question. We have a limited amount of time. I just asked you, Madam Secretary, whether or not you or the Department of Homeland Security are taking any action to facilitate the 9-0 Supreme Court decision to facilitate his return. This is a very simple question. Are you taking any action to facilitate his return, or are you not?
This administration is following and complying with all federal court orders
so,
to make sure that we
So you are, because the court ordered that you facilitate his return. So you are facilitating his return.
Sir, Senator, thank you for the question. But what I would
Madam
tell you
Secretary,
is that we are following court orders, and that your advocacy for a known terrorist is alarming to me.
Madam Secretary,
it's alarming to me because he's a human smuggler.
Madam
He's a
Secretary,
wife
I'm going to have to
beater
reclaim
and
it.
a terrorist, and he's not a U.S. citizen. He's a citizen of El Salvador, and he's home. If he were to come back
Madam
here,
Secretary,
we would take him immediately.
All right,
back
I'm going to have to, Madam Secretary, you should know a couple facts then, which is, number one, in 2019, the immigration court said that he should not be returned to El Salvador because it would put his life in danger. The Trump administration at the time did not appeal that decision. After that, he got a work permit and was working legally in the United States of America. This is also why the district court and the appellate court and the Supreme Court have ruled as they have. I suggest that rather than make these statements here, that you and the Trump administration make them in court under oath, because despite what you just said, the federal district court, whose judge is hearing this case right now, said, and I'm quoting, that the administration has provided no evidence linking Abrego Garcia to MS-13 or any other terrorist activity. I'm not vouching for the man. I'm vouching for his due process rights.
Sir.
No, Madam Secretary, with respect.
I would suggest that you defend and
Madam,
stand alongside the victims of illegal crime.
This is political rhetoric.
Citizens who live here and are United States Americans. I would suggest you advocate for them as hard
Madam
as you do
Secretary,
I
I know you're doing a political speech here.
No, I'm
I
not,
get it.
sir.
I'm asking questions of law. No, you're just spewing
I truly
rhetoric.
believe this. I
Well, you're
truly believe
spewing
this as an
rhetoric. Let me ask
American.
you this: Do you agree with Justice Scalia in the Supreme Court opinion in Reno v. Flores that, I'm quoting, "It is well established that the Fifth Amendment entitles aliens to due process of law in deportation proceedings." End of quote.
Sir, we are utilizing every due process tool that this Congress has afforded us.
This is-
the Congress decides what
Madam
due process
Secretary,
is appropriate for every situation. Expedited removal is a due process that you have afforded us that we are utilizing. The Alien Enemies Act.
I'm going
is
to
another
reclaim my
tool that
time,
we're
Madam
utilizing.
Secretary.
So
You
we are
are-
giving due
Madam
process
Secretary.
and using the tools
Madam
that
Secretary,
this Congress has given
this
us.
is really, I'm asking sort of simple questions of law. And simple questions like, are you complying with the 9-0 Supreme Court decision? And you seem to think that's some kind of trick question. Let me ask you this. You were down at CCOT in El Salvador, and you said, and that, I'm quoting, "It is one of the tools in the toolkit that we will use." And it's well known that the Trump administration is paying the government of El Salvador to keep these individuals, including those who the U.S. courts have determined were illegally taken out of the country in violation of their due process rights. Have you seen the grant document between the United States and the government of El Salvador with respect to the CCOT?
It's important that everybody knows the consequences of what happens for their actions in this country. When you break the law and you're a member of a foreign
Madam
terrorist
Secretary, I asked you a
organization, there are
question. Have you
consequences
seen
to
the
that.
document? This is not hard.
Yes, I have.
Okay. And what are the provisions of the document? So do you know what entities in El Salvador are
Sir,
receiving
I'm
the
sure
funds?
you can see this document as well and have looked at it for
I'm
evaluation.
glad you
as
raised
well.
that, Madam Secretary, because I sent you a letter along with many of my colleagues here on April 8th asking for, among other things, that document. Will you respond to the letter that we sent?
I will respond to your letter.
Can I get some sense of when?
We will take a look at it. I don't remember seeing your letter yet, but I will certainly
Well,
take a
it's
look
been
at
there
it.
over a
and give you
month.
The
response.
senator's time has
No,
expired.
Madam Chair.
Senator Kennedy?
Madam Chair.
Madam
The
Secretary.
Secretary, I have some additional questions.
No,
related
sir,
to
that's up to
Clara
you to manage that time. Senator Kennedy.
Madam
Well, I
Secretary.
need a little help from a chair that respects the members of the
Madam
committee. I'm sorry,
Secretary.
Madam Chair. This is
It began as a simple question, asked with the patience of a lawyer and the urgency of a senator. Are you or is DHS taking any action to comply with a unanimous Supreme Court order to facilitate Kilmar Abrego Garcia's return to the United States? Yes or no? Senator Chris Van Hollen pressed. The clock on his time ticked louder than the microphones. Across the dais, the Secretary answered in abstractions. The administration is following all federal court orders. Van Hollen tried again, narrowing the lens. Compliance with a 9-0 ruling is not a slogan, he reminded her. It's an action. The reply was a pivot and a charge. Your advocacy for a known terrorist is alarming. The air in the room shifted. What had been a question of law became a test of narrative power. From that moment on, the hearing unspooled a deeper conflict. Van Hollen returned to the record, 2019, an immigration court's finding that returning Abrego Garcia to El Salvador would endanger his life. No appeal by the Trump administration, a work permit issued, legal employment in the United States. He invoked the lower court, the appellate court, the Supreme Court. He read from the district judge. No evidence linking the man to MS-13 or any other terrorist activity. He made clear what he was, and wasn't, defending. I'm not vouching for the man. I'm vouching for his due process. The Secretary answered with a different frame. National security, consequences, the prerogatives of the executive. She insisted they were using every tool Congress provided, including expedited removal. She invoked the Alien Enemies Authority and the broad palette of discretion that executive agencies often claim in the border's gray zones. When pressed about funding arrangements with El Salvador, about CCOT, the tool in the toolkit, she acknowledged she'd seen the grant document and promised to respond to the senator's April 8th letter. The words, "You can see this document," landed with the weight of an unopened door. This exchange mattered because it illuminated a fault line in American governance that is as old as the Republic and as current as tonight's headline. The contest between due process and fear, between the rule of law and the rhetoric that seeks to outrun it. Van Hollen anchored himself in the Constitution's slow, exacting architecture. The Fifth Amendment's guarantee, affirmed by Justice Scalia in Reno v. Flores, that aliens are entitled to due process in deportation proceedings. He asked whether compliance with a 9-0 Supreme Court decision was occurring not in theory, but in fact, whether agencies were taking the steps the court required to undo what lower courts had called unlawful. The Secretary spoke in the language of emergency, dangerous individuals, foreign terror, the duty to protect. 2 scripts, 1 hearing. But the facts that surfaced through the crosstalk told a plainer story. A federal judge found no evidence of terrorist activity. An earlier immigration court deemed return to El Salvador dangerous. A man once authorized to work here was removed in a manner that courts, at every level, found deficient, and a Supreme Court, unanimous, ordered a remedy. In that light, the question, "Are you complying?" is not a trap. It's the threshold test of constitutional government. There is a reason the senator repeated himself. In a functioning democracy, power does not get to rename a person terrorist after a court says the evidence isn't there. In a functioning democracy, executive agencies do not hide the ball on international arrangements whose very purpose is to hold people far from the reach of American courts. Law either binds power or it does not. If compliance can be replaced by slogans, rulings by talking points, then our system is not co-equal. It is ornamental. The Secretary's insistence that Congress itself defines the process, that expedited removal is a tool duly granted, is not wrong in the abstract. Congress does legislate the contours of procedure, but those contours are measured against the Constitution and enforced by the courts. When the courts speak with unanimity, the argument is not about tools anymore. It is about obedience. Rhetoric cannot absolve noncompliance. Patriotism cannot excuse it. Security, invoked without evidence, cannot override a 9-0 command. And yet, in that room, you could hear the gravitational pull of fear. It is potent. It always has been. It asks us to look past the absence of evidence and imagine the worst. It suggests that process is a luxury for calmer days. It tempts us to trade our principles for a promise of safety that never quite arrives. It was into this gravity that Van Hollen planted a stake. I'm not vouching for the man, I'm vouching for his due process. That sentence is the hinge of the American idea. It insists that rights are not rewards for saintly biographies. They are restraints upon government, even when the person before it is unpopular, unknown, or accused. The details he pursued, the grant document with El Salvador, the terms of SECOT, the mechanics of who receives funds and for what, may sound like footnotes. They are not. They are the paper trail by which we judge whether the executive is partnering with foreign authorities to sidestep domestic law, holding people offshore to evade court orders, or honoring the constitutional limits that make our power legitimate in the eyes of the world. Transparency is not charity. It is the price of authority in a democracy. And so the moral meaning of the exchange was not about one man alone. It was about us. About whether we still believe that the state must prove, not proclaim, that courts decide, not cable news, that the Constitution is a living constraint, not a ceremonial script. It was about whether we recognize that due process is not a loophole for villains, but the firewall for everyone else, because once the government learns it can ignore the rules for them, it will ignore the rules for you. When the chair called time, the questions did not end. They traveled with us out of that hearing room. Are we a nation that obeys unanimous Supreme Court orders, or one that treats them as suggestions? Are we a people who demand documents and facts, or an audience satisfied with insinuation? Do we accept the slow discipline of law, or surrender to the faster thrills of power? Here is the truth at the heart of this tense exchange. The strength of America is not measured by how fiercely we can denounce, but by how faithfully we can comply. With the Constitution, with the courts, with the promise that even in the heat of politics, law remains cool and binding. If we want to keep that promise, we have to fight for it. Stand with the principle, not the personalities. Stand with due process, demand the documents, demand compliance, and don't look away. Subscribe to Liberal Line, support our work, help us keep the cameras pointed, the facts straight, and the pressure on, until the rule of law is not a talking point, but a living reality.